Good morning, Ms. Miller. Mr. Femino?
Good morning. May it please the court?
Thank you.
My name is Leonard Femino. I represent Ronald and Catherine Sheehan. Any attorney in Massachusetts who deals in real estate and who represents a purchaser of real estate who is required to review a title and decide whether there's clear record and marketable title has a serious problem in a case like this, where there is a variance decision. We know as attorneys that every word has a meaning that must be followed. We know under 40A, Section 10, that variances are rare commodities, that they must be strictly construed, that...
When they do title searches, don't they go to the city hall and look for variances?
Absolutely. And this variance is recorded, and it's at City Hall.
And does it say something about one story and garage?
It says specifically, permission is granted for an addition 22 by 22 garage, left side setback. So very clearly, the lawyer reading this title knows what's there.
But you're trying to build something that's bigger than 22
No,
by
I'm-
22. I mean,
I'm on the other side.
yeah, okay, but aren't they trying to build something that's bigger than 22 by 22?
Just for clarity, I'm the attorney representing the abutter, and we're the ones that are trying to keep it one story, a 22 by 22 garage. We're the ones that were at the 1995 variance where a garage was what was granted, and we want to keep it a garage.
Okay, I'm trying to find out about the square footage, because in the documents that we've been reading, there are several different descriptions. Sometimes it says 22 by 26, sometimes it says 22 by 22, 22 by 24. What are the dimensions of the present, what are the dimensions that the people want to build at the present time?
At the present time, what they have built is a 22 by 26 addition, second story. That's on the documents that are in your appendix for what was requested and granted by the building inspector in 2003.
Mr. Femino?
Yes.
Regarding the building inspector gave permission to them to build this second floor. How much discretion does the building inspector have?
I believe the building inspector has no discretion because you have Chapter 48, Section 10.
Well, let me ask you this. If they asked to build a second floor that had exactly the same dimensions as the first floor, would we still have a problem here?
Yes, we would.
Why?
Because the word garage was placed in the decision with the attorney who has to certify title knows it's a garage. That was the battleground.
Well, let me back up then. Are you assuming that every building that has two floors is using that space for living space?
We know
Aren't there two-story garages?
there are. If this were a two-story garage, I would have a difficult time here. But it's not a two-story garage.
Is there evidence in the record that tells us that how the second floor is being used? What does the record tell us?
I wasn't the trial attorney, but I believe with the Superior Court, the record was silent
All right.
as to what.
So aren't you making an assumption that it's not supported by the record? You're saying it's living space.
You're saying it, whatever it is.
Whatever it is.
It's not a garage.
It's not a garage.
Mr. Femino,
And again,
go ahead.
part of the reason I'm here is we have a lower court decision, which, pages 65 through 67 of your appendix, there's nothing there. There are no facts found by the lower court. There's no law cited.
May I ask you two questions? First, the variance had nothing to do with use, correct? In other words, the variance that was sought had nothing to do with use.
If I may, what they requested, the need for the variance was the incredible encroachment on a 20-foot side yard setback.
But the use was permitted.
A garage
on
is,
the property.
Yes, it is. But please understand, the request, if the request in 1995 was, we want to build an addition,
Unspecified.
okay, unspecified, in 1995, that would have been the battleground. The Sheehan's were there in 1995. They would have contested it. It would have been brought to court at that time, whichever way it went. And the issue would have been, we don't want that intrusive use 1 foot from my property. But when, and this is important because out in the field, when we appear at zoning boards and there's opposition, there's always compromise. And compromise is what sometimes is behind these decisions. And this was a compromise.
May I ask you this? I assume that nowhere in the record of the original grant of variance is there a height limitation specified
It's not specified
in terms of feet.
in terms of feet. There were plans that were not attached to the decision. Of course, reading the decision carefully, it talks about, after it says 22 times 22 garage, showing a side yard setback. And Mr. Lucier, in his affidavit that's with the court, on paragraph 3 of his affidavit, did admit there were plans submitted with a 1995 variance.
And his the application also included a height, 1 story, 14
Yes.
feet.
The applications, there were plans clearly showing a garage level of 9 feet with a pitch roof going up to 14 feet.
Why do we have to bother with what this second floor is going to be used for? If he applied originally, as the record seems to indisputably show, to build a 1-story, 2-car garage, and he got permission to do that, isn't that the end of it? You can't expand that any further.
I would agree with you, Your Honor. They did not say
Variances are very strictly construed. They're lightly granted in the first place. They're almost impossible to get if they're challenged. They're overruled all the time. So how in the dickens can you double the size of this, in essence, and leave it somewhat ambiguous on what the second floor is going to be used for and expect that that is permissible when one is holding a variance?
In 1995, everyone at the table knew it was a 1-story garage.
Mr.
Isn't
Perroncello,
there another-
may I ask you a separate question? The variance was for 22 by 22. You have told me that what has been built is 22 by 26, correct?
Yes.
Is that undisputed? If I look at this record, is it undisputed that what was put on top is 22 by 26?
That would be undisputed, yes.
Okay. I have a second question, and unfortunately I have to refer you to I'm holding it up, the plan. The lot line, at least based on the plan, appears to be at a diagonal to the garage extension. Is the additional 4 feet front and back, only front, only back, if you know?
I do know, Your Honor. The addition, and it's shown, I think, on page 40 of the appendix,
Right?
is 4 feet out the back.
The back being not Lowell Street.
Not Lowell Street, the backyard away from Lowell Street.
Wouldn't that bring it closer than 1 foot to the property line?
I did not handle the case in the lower court, Your Honor, and
But
yes.
isn't that an obvious influence? So apart from anything else, if you simply look at the variance, it's a variance that says you can build to within 1 foot of the property line. They have now built to within something less than 1 foot of the property line. Am
When
I
you
correct?
view it from the street,
I just want to know what it shows, because this is a diagonal, because the garage appears not to be parallel. The outer wall closest to the property line appears not to be parallel with the boundary line.
if this matter ever it goes before a lower court, the 4 foot in the rear appears to be on the property line, on the fence.
So isn't that an independent reason why this addition is not within the original variance?
Absolutely.
Are you
Was that
aside-
raised below at all?
Excuse me?
Was that raised below?
The 22 by 26 was.
But not the fact that that made it closer to the property line than was originally permitted.
It's in the document that was before the lower court.
Is it clear from the record that the additional 4 feet is not at the Lowell Street side of the garage? In other words, it's because, believe me, there are references to back and front.
I don't think it's clear in the lower court which 4 feet. It's just 22 by 26.
Well, it couldn't be. It couldn't be the side yard, an extension of the side yard, because it would be on your client's property by 3 feet.
Wait,
I mean,
no,
it could be the
it's
Lowell
not going
Street.
out.
It could be on the Lowell Street side, in
Right.
which case it
It's
was...
actually the backyard is where the expansion of the 4 feet is in the backyard of the property.
And I tell you
But
what,
A
because
side yard abutter or a backyard abutter?
I'm a side yard abutter, the Sheehan's are a side yard abutter.
So the extension of the garage, the side wall of the garage will come no closer to your client's property than it currently does.
No, it actually has come closer with the addition built. Because the structure and the property line do not run parallel, as you'll see on page 40 of the appendix. Because the front yard is further from the property line than the backyard,
Yeah.
then the 4 foot actually extends more closer and probably on the property line of the Sheehan's.
But that was not raised below, and that wasn't raised, I take it, either before the Zoning Board of Appeals or the Superior Court.
Only in the fact that there's a plan.
All right, let me, you said something earlier on I wanted to explore a little bit. You said that, in essence, the conversion of this from a garage to some other use violated the variance. Is that the case, let us say, if there was no addition built on top of the garage, but the garage was simply converted to a living room, as they frequently are? Would that be a violation of the variance?
Yes,
Why?
because there was a special condition.
Was there a special condition?
Why,
Isn't that the real question here, is whether,
Yes.
is how specific you have to make something in order that it be a special condition?
yes. And here's why. The one-page variance has several lines in it, and most of it is boilerplate. And it comes down to one sentence. And so the lawyer, the title examiner, the plot plan fellow who's doing the plot plan for the bank, is going to look at that language and say, what is it? It's a 22 by 22 garage. And again, I know that a variance is a waiver of zoning. And I know that a garage is a use that's permitted. But we're now talking about an area where there was an expansion. And in 1995, the garage factor is important. And
I'm not talking about an expansion here. My question is simply if they converted that garage as built to a living room, would that violate the variance or require another variance?
yes, again, I would say because of Barron Chevrolet. Look at footnote 6 of that case. What was so important was that, again, like this case, is all they needed was a variance for side yard setback in Barron Chevrolet, and they got that. It was important in that decision that there were no conditions. Both the 1969 and the 1972 variances, there was no restrictive language. That's not what we have here. We have one line, 22 by 22 garage.
Paren, attached 22 by 22 foot
Garage, in parentheses, which is emphasis
Okay,
of
so
what
that's
addition.
so that is the limitation, that little paren.
That is a condition. It has to be a
All
condition.
right, so building a 22 by 22 foot second floor to that garage, maybe for storage or garage-related stuff. My garage has a little storage area on top of it. Would that be a violation of the variance?
If it were a 22 by 22 second floor garage, based on that decision, and no plans being at the Registry of Deeds, that would be correct.
Because the variance didn't incorporate specific plans or specific terms other than 22 by 22 foot garage.
Yes, and I agree with that statement, even though we have a problem here, because in a special permit situation, you have the Goldhirsch type analysis, where are you intensifying the use, and you look at bulk and light and all these other issues, and now we have a variance situation where it's a much more stringent test, but yet The waiver was given, so waiver is different, a 22 by 22 garage, and in the city of Peabody situation, they didn't attach plans, which means lawyers don't see the plans when they're at the registry of deeds.
But they're on notice that there was an application made for a variance, and there were plans attached to the application. They can go, does everything have to be at the registry of deeds?
No, there's going to be a problem if there's adequate records at town hall or city hall which show plans, and if the fellow who is doing the plot plan lets the lawyer know that this is supposed to be a one-story garage, in reality, there's going to be a problem.
Mr. Femino, may I ask you a question about relief? I do not have a copy of your complaint here, but I see in your brief that what you've requested is a reversal of the judgment in the Superior Court. That's perfectly straightforward. And find that the owner is required to seek zoning relief. At the present time, you are not seeking any additional relief?
Would love some law.
No,
In
no.
that-
I'm just saying, assuming that we find in your favor, that we rule in your favor, you are saying that what is appropriate is that they have to go back and get a variance?
And D. Giovanni would suggest that they have to go back and either file for a new variance or a modification of the old variance. So we're back in the city of Peabody, because that's the right of the appellee in this situation.
Thank you, Mr. Femino.
Thank you.
Mr. Kilty?
Good morning, Your Honors. My name is John Kelty, and I have the privilege of representing Kenneth J. Lucier, who is the appellee in this matter that appears before you this morning. And a couple of issues that I'd like to comment before my more formal presentation. There's no evidence in the lower court of any second floor being bigger. There's no evidence in the lower court that was ever presented.
There's no evidence that it's 22 by
26. No. Nobody ever submitted a plan. Nobody ever, there was testimony.
Isn't that at very minimum a material issue, an issue of material fact then?
There was never an argument by the appellant Sheehan that the issue presented to the court was that it was indeed bigger. And it does bump out in the front. It does bump out in the back.
It does bump out in the front. And
Yes, it does.
Well, aren't you just agreeing that it's bigger than 22?
It is bigger, but we don't know that it's 22 by 26, Your Honor.
But we know that it's bigger than 22 by 22.
We know that it's bigger, and we also suggested that a lower court that there is no further encroachment on the side yard, that despite the fact that the property line appears to be skewed, there was evidence presented at the Board of Appeals showing that it still conformed to the 1-foot side yard, and that the encroachment would be in the rear, which is required to be 35 feet, and I think we have some 60-foot side yard. So there was never an issue.
Doesn't the case have to go back to decide all these critical facts? Why is this appropriate for summary judgment?
Your Honor,
we
it
don't
was
know
appropriate.
exactly how big it is. We're, a little bit, and we don't know what it's going to be used for. We're a little bit in doubt on to what extent it might or might not encroach.
There was absolute knowledge as to the use. In City of Peabody, the side yard requirement is 5 feet if it's detached, and it is 20 feet if it's attached. The predecessor in title, it is not the Luciers that obtained this first variance. It was their predecessor in 1995 in title. It was some years later that the Luciers came forward to seek a second-floor bedroom.
Mr. Kelly, let me
So you
ask
admit
this.
it's going to be a living space?
Yes, it is.
It is.
It's finished. It's been finished since this case started, Your Honor.
Mr. Kelly, let me ask you this. If it's larger than 22 by 22, regardless of if it encroaches further, why would that not be a violation of the variance?
The variance was for side yard. Simply stated, it was a 1-foot side yard, and then very importantly, it is in parens. City of Peabody, before which I've been practicing for 20-plus years, very carefully says with the following conditions, and they would say that the garage be solely used as a garage. They would say that it happens in this case that it says a 22 by 22 foot addition is allowed, and then says parenthetically garage. 22 by, it says a 1-foot side yard for an addition is allowed by the variance, and then in parens, which is very important, it is clearly not a condition.
Then,
In the section where it says...
No,
with-
you say it's clearly not a condition, but we tend to give meaning to every word in a variance. Is that just surplusage? I mean, the word garage means nothing?
Yes, Your Honor. I think clearly it does in the fact, given the fact that in this instance, it is parenthetical. It is an aside.
Well, under your theory of this case, then, if your client needed a variance and obtained a variance for a fenced enclosure to keep a dog, and the fence protruded or protruded into the side yard requirement such that it was 1 foot away from your abutter's boundary, you could then convert that fenced enclosure into a 2-story living space.
I believe, yes, if you have a 1-foot side yard, if that's what the variance is given to you, single and two-family homes get to use that footprint. Absolutely, Your Honor.
But then aren't you ignoring, if we say that variances are strictly construed, aren't you ignoring the words of the variance?
I think that variances are strictly construed when drafted properly, and in this instance, the City of Peabody drafted improperly if indeed they meant to limit this to a 1-story garage.
Well, they might have drafted it improperly, but you're saying it should say, with the following special conditions.
Yes. And it does, and in that section, they don't...
No, but they've said garage. So any title examiner, what is the title examiner to make of that? Or if it says fenced-in dog pen?
But the use was not what was at issue. That was a question
No, I
asked
understand
early
that.
on.
But sometimes, as you know, variances are granted because the city looks at what the impact on the neighbor is going to be. And indeed, neighbors often may or may not choose to oppose it if they say it's a fenced-in, dog run. That's fine.
Mm-hmm.
But we don't want to have we certainly would have opposed it if we thought it was going to be a 2-story built-in, fully built-in structure. Makes a huge difference to the abutter.
I would agree that it makes a difference to the abutter, but I suggest strongly in this instance it's not appropriate to apply that standard. My client went some years later, asked for a building permit, was given the building permit correctly by the building inspector, began the construction. Then through the construction process, there was an appeal taken. That's what brought that matter before the Superior Court.
What happened at the zoning board?
Zoning board, although their town council, city solicitor, had advised them that the building permit was properly issued, they overturned the building inspector.
Well, do we give them any deference or not?
To whom?
The zoning board.
No. The building inspector is the enforcement officer with respect to zoning, and he properly issued a building permit for the second floor.
You say that the words in parentheses aren't really important and we can ignore them. Now, it says 22-foot by 22-foot attached garage.
Yes.
Now, what if they built a garage that wasn't attached? Forget property line and assume
They would have
that-
needed a 5-foot side yard. It would have triggered if it
So
was not attached.
could they have built a non-attached garage under this
I think they could have.
variance?
Because
You
they
think
were given
could
a
have?
1 foot, sure.
So in other words, you're asking us, in essence, to read out some of the words in the variance.
Yes.
In fact,
But
you're
if
asking
you're
us
looking-
to read out the measurements, 22 by 22, aren't you?
Yes, to the extent that they are all superfluous, that they give rise, because it is attached, they give rise to that structure
Okay.
now being 1 foot from the side yard.
What are we
Yes.
left with then in the variance? What are we left with if we
The
read-
1 foot side yard,
That's all.
the
So
dimensional
that's-
regulations.
So in other words, the board granted your client permission to build anything
Anything
that
up to-
was,
They
as long
granted
as they were
predecessor.
1 foot away from the property line.
Yes.
Does that really make sense?
Where in
It-
Chapter
it-
40A, Section 10, does it say what particular words a zoning board needs to use?
It does not. I don't believe 4810
Did you-
directs, but for hardship, but for there must be a finding of hardship. It doesn't direct otherwise what words boards should use. Boards need to be careful in construing what it is they've allowed.
Correct, and here they've said 22 by 22 garage.
However,
Attached.
not as a condition, not as a limitation, such as would ordinarily be done. Very, very generally, you see with the following conditions.
I know very, very generally you keep saying that. Was there anything in the record? Was there anything that they always do this at Peabody? I mean, You're asking us...
There's nothing in the lower record but for testimony at the hearing that was held by the ZBA that it was not placed in there as a condition. And there were members of the board who, well, it's irrelevant, but who recognized that it was not drafted as a condition.
So could they build a 4-story?
No, because then they would exceed height.
What's the height?
35 feet. They had 1 foot, 35 feet.
They can do anything under the zoning under the zoning bylaw that would permit construction up to 1 foot from the side yard.
When drafted in this manner, yes.
Well, 35 feet would be 3 stories, wouldn't it?
It would depend, Your Honor.
Well, there would be other
on the
building
stories.
code
I would suggest that 4 stories would give rise to a different variance.
I mean, the point is that building this second story is completely consistent with every building code zoning requirement
Correct.
in the town.
Correct.
Other than the side yard setback, which you say this variance provides.
Yes.
So you couldn't build something 4 stories if
If it exceeded the height
if it
requirement.
exceeded the height requirement.
Correct.
But you could build 3 stories.
Arguably, Your Honor, yes.
No, I mean, as Justice
Yes.
Laney suggested, it's not unusual. 35 feet is very high.
Yes, it is.
I mean, it is high.
And it's measured to the halfway point, the peak of the roof, to the soffit to the ridge.
Correct.
Your Honor, with respect to this, the other issue that was raised, the procedural issue, we thought that Rule 52A controlled that and that the judge was not required to make findings of fact and rulings of law, and that indeed it was
that's elementary. You don't make any findings of fact on a summary judgment.
Well, that was an issue that you had put out for response to, Your Honor. So I speak just briefly to that, that's all. I'm finished with that argument. The Goldhirsch case cited by my brother is absolutely distinguishable. The Goldhirsch case was a pre-existing non-conforming structure, and as such, that began the 40A6 findings that are now popular and pursued and followed with regard to special permits. Very distinguishable from this. We are solely arguing, I think that the bench has certainly honed in on what the issue is, whether or not that was a condition, 22 by 22 attached garage, whether that was specifically a condition or whether it was truly parenthetical, that happened to be what was being requested and that the relief that was granted was the 1 foot side yard. We say emphatically that the relief granted was the 1 foot side yard, that there's nothing on the record that says that despite the fact that there's a bump out on the top floor, that gives rise to any further relief being necessary. It did not. And, Your Honors, we believe that the lower court should be upheld.
Thank you, Mr. Kelton.